facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The officer smells marijuana, does a search, and finds 3 sealed bags in the back seat. But here's the twist. Moore swears it's CBD, not weed. And that difference? It could decide whether he walks free or faces jail time. Now, for anyone wondering, probable cause means police need reasonable grounds to believe a crime has been committed before they can search or arrest you. And in this case, that smell of marijuana is all the officer needed to open the door, literally.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you say
61 and a 50?
Got it. Okay.
And the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car. But the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD, it's in my backpack. When you search, you're gonna find it, it's gonna be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little flower.
Is it?
It was a flower. So
It is a flower.
Mm-hmm. So I do know that the CBD flower and cannabis flower, they look very similar. So
Your Honor, if I may, so as the DIMS established, so the odor was enough from the search, and finding that leafy substance is enough because upon further testing, it may or may not, but just for the purpose of probable cause.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're gonna test it. If it tests different, then there we may have an issue.
Yeah.
But as far as probable cause, then, your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's gonna happen? You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's gonna happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not gonna put any conditions, just be careful. Don't pick up any new cases because I'm gonna lose it at that point. You've got a great lawyer, listen to her, she'll take care of you. If she tells me she can't get a hold of you, I'm gonna revoke your bond. Just be good, don't pick up any new cases. If you're gonna drive, make sure you have insurance, car insurance, all right? Okay, guys.
thank you.
Yes, ma'am.
Yeah.
Was today his regular setting or was it a setting that we brought him in because he has bond violations?
It's his regular setting.
Okay,
We had accepted the plea offer and we're ready to move forward today, before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life.
This judge isn't here for small talk. He's a force. Watch how he warns him with chilling precision. I can take you there, kicking and screaming, and I don't care what's going on in your life. That's not just courtroom flair, that's legal authority. Judges have the power to amend bond conditions at any time, and that means she could literally remand him to rehab on the spot if he slips up again. And here's what makes this case fascinating: the plea deal. The prosecution agrees to reduce his charge from a second offense DWI to a first, which saves him mandatory jail time. But the judge makes it crystal clear: one more misstep, and Harrison could be facing a full year behind bars, or worse.
But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to a year and a half of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first, and I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash, and one false move, they're going to file a motion to revoke. And if they prove it to me that you violated probation, get ready. For you to complete what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car, because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation, and if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first, so it's a $3,000 fee, but let me ask you this, is this a 0.15 or above?
To your honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be a 0.15.
Okay. You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, sir. Thank you, Ken. All right.
Judge, are you issuing a military license? He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay, yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay, so if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So, hey, Jillian.
Yes, sir. I have a legal white one docket. The state's offered PTI. She said that her home was getting off the fan, so she actually reached out to mobile and she wasn't getting the bonding company or me during that time period.
Come up, Miss White.
I will say before that time period, Ms. White was very communicative with me. I did speak with her regularly, and then all of a sudden I didn't. So,
You really expect us, you're gonna blame it on AT&T?
No, sir, I honestly,
You are even lucky to be getting a PTI offer at this point with as many times as you've taken off and the fact that your case is 250 days. We set cases for trial at 180 days, and your case is now 240 days old. What have you offered?
So we offered a 6-month PTI where she has to take a effective decision-making class and no drugs and alcohol.
Like the long effective decision-making class?
Discuss the online one.
yeah, I mean,
If you're gonna do
Yeah, I believe it's a standard. Yeah.
that's what you guys are gonna do, then I'll give her a week to get it done. But I'm not doing any more. If you don't have it done in a week, I don't care if you come kicking, screaming, you blame it on whoever it may be, prevent you from doing it. I'm going to set your case for trial, or you're gonna end up taking another offer and you'll end up with a conviction. But you can't expect good things when you repeatedly take off, fail to communicate with your client, and you just go AWOL. Would we care if you don't care? It's a rhetorical question you don't have to answer. But that's what's going on in our mind here. Why would we care if you don't care? You have been given an opportunity now. The ball is in your court. You have 1 week. If you don't get it done in that week, that tells you that you truly don't care. And I won't take anything else. Do you understand?
yes, sir,
One
next Tuesday.
week. Okay?
thank you, Judge.
All right. So you are Kenneth Allen, correct? So Mr. Allen, we had started to do probable cause, but I wanted to wait over there. So that we get your perspective on it. So, all right, so you stand charged with criminal trespass. You're facing up to 6 months in jail. We're gonna do probable cause again now that your lawyer's here. Okay, please.
On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, who both stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant, and the complainant and witness pointed to him, stating that it was indeed the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Is the witness.
So let me see, Your Honors.
I mean, he had authority to be there, and I know that you can revoke that, when you overstay your welcome.
Yes,
right?
Judge. So the complainant is the office manager and the witness is security guard.
Okay. Did you want to add anything?
Well, Judge, my issue is he's been at that facility for years, and he has 3 separate doctors within the same UT facility, and he was there for his doctor's appointment. And there's some contention as far as whether he was asked to leave or not, considering that doctor's appointments take months to schedule in advance, sometimes up to 6 months.
You're about to watch the judge try to untangle that knot. Was this man simply confused about his appointments? Or did he deliberately defy a lawful order to leave? And what does it mean when one office bans you but your other doctors are still inside the same building? Stick around, because this hearing is about to blur the lines between patients' rights and property rights, with a judge who's trying hard to keep the peace and a defendant who might just talk himself into deeper trouble. Let's get into it.
So I don't believe that if he had a right to be able to see the doctor, I don't believe that a person that's unidentified, the original complainant, I think her name was Amy, should be able to come in to tell him to leave, if in fact she even told him to. So I think there's...
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yes, Judge. And then he still refused to leave once security got involved. And we contacted the complainant as well, and to add
You
more.
have spoken to the complainant?
Yes.
Oh, okay, tell me.
And the complainant said that the defendant was sitting in the lobby after his visit, and the reason he was asked to leave is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had concluded, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause to go forward now. Did you speak to them? Tell me.
They said he's no longer a patient.
No longer a patient. Okay. So you can't go back there. Okay, Mr. Proler, you must find a doctor, but it appears that they don't want you to go there anymore at this particular doctor's office. Okay.
Well, Judge, may I add, like I mentioned, he has 3 separate doctors within the same building. So is the court asking him to stay away from that particular single
Correct.
office?
Right.
Okay,
So if you have business in another part of the building, you can go. Just don't go back to this office, because the chances are, if you go back there, they're probably going to call the police and they're going to charge you with another trespass. So don't go back over there, because they've warned you not to go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But okay, so then just stay away from wherever that office is, and you can use the other 2 places. But I'm not barring you from the building, just from going back to that particular office. What is the confusion?
Oh, I want to bring to your attention this alleged other incident.
Doesn't matter.
Yeah.
Okay.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
It's a UT Physicians Bel Air station, so I don't know how they organized that office there. So I think just one system. It's not necessarily separate offices, like different. Maybe just be
If he has 2 other doctors that he sees there.
And that's part of the issue, because again, it's part of the same system. So I don't know. They do have multiple doctors there, but it would be at the same facility. And they told us that he's no longer a patient at the facility. So presumably that means no doctors there, but we could clarify if you would
I
like.
think you need to.
Yes,
You definitely need to, because this could be a potential problem.
yes, we can
And
certainly
he's saying
clarify.
he's still seeing two other doctors
Yes,
there. They may not know of the other two doctors. You want to do that real quick to see, real quick? Can you give me 5-10 minutes? Let me see. So, you know, hey, Alex, also see, I mean, are there different, you know, in most like buildings, there's suite 101, 102, 201, 202. How do they do it over there?
Yes,
Is it
Judge.
by like
We'll see how they organize
the
this.
suite, and then
Yes, Judge.
is it possible that he can see the other two?
Yes,
And
Judge.
then, okay, yeah.
Oh, so it's continuous. October.
It's the 30125.
This container.
Yeah.
Uh-huh.
Sam's. Yeah, this is trash. I mean, do you want any of these? Throw them away because you're rather old. You want it?
No.
Are you sure? I'm gonna throw it away.
They have access to
Counsel,
Yes.
come on out.
So, I was doing my due diligence on my end. And
Great.
I came in contact with, another provider in the facility, and he is a current patient there at this time.
Right.
So I just wanted to verify on our side.
Alex, did you hear this?
Oh, I apologize.
So-
And Will, because this is your deal as well. So they've verified that counsel has verified that he's seeing another doctor at that facility.
Okay,
So what we'll do, like I said, you're on notice of what you can and can't do. We don't want you to go to the complaining witnesses in this, over there, wherever they may be, wherever their office is. You understand? You can see your doctor if you have another doctor there, but I don't want you to have contact with these people here.
If I understand you correctly, Judge, I can continue doctor's appointments there, but don't.
How is the facility divided up?
This building is not the best building to have doctors in, to be perfectly honest with you. But you get off the elevator or stairwell, whatever route you choose, and like it kind of wings off. Let's say.
Is there a possibility that you're going to run into these people?
The same floor, separate floors.
Yeah, I'm sorry. Under what circumstances, Judge?
I don't want you to run into these people.
Is there, a
And
way,
we say these people.
is there a way you can get to your other doctors without going to the cardiologist? In front of that building, in front of that suite?
Oh, I think I understand what you're saying.
Is there a different way you can go around?
I mean, it shouldn't be this difficult.
I know. I agree.
I don't understand why I mean, what is the doctor's name, or what is the facility? Who are we talking
so
about
we're
here?
talking about an Amy Whitetree, so she's the office manager for whatever department she's in.
I don't want you to have contact with these people.
Can I tell you something, Judge? I don't know. I mean, I now know who she is, but she did not identify herself on the date of the incident.
Okay.
And she didn't have a UT badge or anything. Some woman came and talked with me. Now I understand she has a name. And sure would like to hear the complete name, if that's okay with you all.
I don't want any more issues. If they call me and they say that you're becoming a disturbance there, I'm going to revoke your bond and I'm going to put you in jail. Do you understand?
I don't blame you.
I don't want to make this any more difficult than it is. You know what you can, you know what you can't do. The condition of your bond is you're not to have any contact with the complaining witnesses in this case, not to go where they work. They don't want you to go where they work. That's it. If we get wind that there's any issues, only one thing's going to happen. You know what you can and can't do. I just don't know how else to explain it. But
I understand.
Sure, that's
Yeah.
pretty clear. And that'll be the only condition, Judge. This is his first contact with law enforcement. He's a retired captain of the Houston Fire Department for 22 years.
Okay.
So he's not gonna be in trouble whatsoever. It's still be circumstances.
Yeah, and if it gets to the point where you may need to find another doctor because it becomes impossible for you not to run into them, but you're the one that's on bond for this case, right? We'll give you as much as we can, but I just don't want any more problems. I don't want them to live in fear. I don't want them to live in, oh my God, is he gonna come back? No, we've told you what the expectations are, that's it, okay? If you have any questions, you've got a lawyer, he can help you out. If there are any issues that arise in the future, you can always come back here. We have an open door policy, so we're always here for you, whatever you may need. Don't take matters into your own hands, and just be good, that's it. We'll have conditions for you to sign after you're done with that, then you're on your way.
And appearances are way for.
Correct,
Okay,
so
thank you.
because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court here, but you must stay in touch with counsel and he will tell you when you have to come back to court.
Sure, sure.
If he tells me that you've gone AWOL and he can't get a hold of you, you're not answering phone calls or text messages, that's when we revoke bonds. You pick up a new case, I'm gonna revoke the bond. Okay? All right, guys. All right, so they're gonna have it filed, let you sign it, and then you're on your way. Okay, of course, thanks. Come on up. Are you Miss Troyanne Marie Britton?
I am.
Miss Britton, you are charged, I'm sorry, you are wanted out of Georgia, Fulton County, Georgia specifically, for possession of a firearm or knife during a commission or of an attempt to commit. I don't know what, it just ends there.
Judge Fleischer.
To commit certain felonies. Your lawyer has asked for me to set you a bond. I don't know anything about you. I've never met you before. So I got to see who you are as to see whether I'm going to set you or not.
Legally speaking, this hearing is about extradition and bond. The court must decide whether to trust her enough to set a bond, meaning she could walk free temporarily, or hold her until Georgia authorities come to collect. But bond isn't just about money, it's about trust. The judge has to believe she's not a flight risk or a danger to the community, two things her record makes very hard to argue. What you're about to see is a fascinating and emotional clash between law, mercy, and accountability. A 19-year-old who's run out of chances faces a judge who's seen this pattern one too many times. So ask yourself, can someone so young truly turn it around? Or has she already crossed the line beyond redemption?
One of the main things is, are you a danger to our community? Number one. Number two, if we set you a bond, are you really going to go back, or are you just going to take flight? Those are the things that we're really concerned with here. Amy, tell me about Miss Britton, or Katie, or is it you, or anyone?
Yes, Judge, I'm here.
Okay.
I would be a little bit concerned, Judge. I am seeing 2 failure to appears already on her criminal history. I see a possession of a pistol by a person under 18.
Wait, what was that?
A possession of a pistol by a person under 18. Interesting charge. And then I see a failure to appear. I see possession of a controlled substance, marijuana charge, willful obstruction of law enforcement officers, and aggravated assault, theft by receiving stolen property, driving without a valid license, another failure to appear.
Is that
so I am a
four
little
failure
bit
to appears?
concerned.
That's 4 failure?
I'm seeing 2 failure to appear, Judge.
Were they fugitive cases or just open cases elsewhere? And where is all that history from?
So I can't tell, Judge, if it's a fugitive case or not. I see that it's out of Fulton County. Let's see. I see Atlanta Police Department. It looks like most of these are out of Fulton County, Judge.
How long ago are the FTAs? Is it recent or?
So one is from 2023, and the other one is from, I'm gonna look for a date, Judge, is from 2024, from 6/28/2024. that appears.
And I'm assuming that 628 one is the one that's holding her right now.
It might be, technically the warrant that we have written down is possession of firearm. So it doesn't specify whether it's a failure to appear warrant
You know
or
when the
not.
hold was placed?
Let's see.
She was booked on our.
It looks like it, I'm sorry, it looks like it's from February of 24. Yeah, it doesn't, like I said, it does not specify that it's for the failure to appear.
Judge, so she hasn't been before your court. This is one of those cases where I'm not asking for a PR bond. I'm asking for a bond that would ensure that she turns herself into Fulton County. I've talked to her about your requirements if you were to set a bond, how that affects her, how that affects the bond. She needs to present herself. She's got criminal history, I'll give you that, but she hasn't been before your court before. We're asking for an opportunity for her to go turn herself in. She's willing to do that within 14 days and show proof of that. If she doesn't turn herself in, well, then I'm not gonna say, but at this point, it sounds like possession of firearms are most of the cases that she has.
All her cases are dangerous cases.
Right.
Assault, ag assault, possession of a pistol. Now she's got a pistol case, committing certain felonies. We don't even know what the felonies are. Do you know?
No, Judge, not at this time.
I only heard of
A bunch of FTAs, at least 2 other FTAs. Now we've got a third. What? You really want me to set you a bond? I want hair. Not gonna happen. No, at some point we got to say when. But you know, you've racked up a bunch of criminal history. How old are you? How old is she?
She's, I think she just turned 19.
19 and all this?
Was I right about that, Troy?
Absolutely not. I'm in shock that you're 19. And Katie, how many priors are we talking here? At least like 6, 7, 8?
It appears so, Judge, yes.
No, I'm sorry, but I just, you scared me, Miss Britton. Really, I don't think that I could trust you. I think if I set you a bond, it's something is going to happen, or you're just not going to go back. And I'm sorry, I can't. All right. The good news is that you've made bond on your other case here. So the time is ticking for George to come get you.
She needs to waive today if she wants that to happen.
I'm sorry?
She will need to waive today.
So the process is that you can either waive or you can fight extradition, in which case they will get a governor's warrant, which will take up to 90 days. But if you waive extradition, that gives Georgia up to 14 days to come get you. And if they don't get you within that 14 days, then Harris County releases you. But at 19, with as many priors as you have, including 2 failure to appears, you really scare me. And I don't think that it would that it's time to pay. Just can't trust you, Ms. Britton. Sorry.
Would you consider any amount?
No, I mean, all that, and you're 19, it's hard enough being a person of color in today's society. And now with all these priors, all you're doing is you're digging yourself a grave. You're making yourself unemployable. You know, this life can be a great journey where you buy nice things, you take nice vacations, you get married, you have kids, and they come up to you, hey, I love you, mommy, I love you, daddy, you know? Or it can be a rotten, miserable of an existence where you're in and out of jail. At 19, all these serious priors, come on. Stop. It's time to grow up. And me giving you a bond now would be just enabling you and telling you what you're doing is okay. It's not. And now we'll wait for Jordan to come get you. Thanks. Ms. Jackson, I wanted to just apprise you that when we have cases of this nature, I forbid you from going back to the place in question. In this place, it's Walmart. You're not allowed to go to Walmart. You're not allowed to go to any Walmart for any reason. It doesn't matter. Do you understand? If we catch you at a Walmart, or if you pick up a new case, I'm going to revoke the bond. I will put you in jail. No more PR bonds. You understand, man? Okay. Thanks. Thanks, Josh. Yeah. Hi, James.
Morning, Judge. I have Michael James. It's an old case, but I was appointed December 9th. I was just appointed about less than a month ago, Judge.
Okay.
And we have a PCI deal worked out where if he does a gun safety course and some anger management, the case will be dismissed. And we get him, how long would you like?
Is he here?
No, Judge, he's here.
Come on up, sir. So a gun class and you said community service?
No, gun safety course and anger management course.
Anger, okay. Is it like a 2 or 3 hour anger management class?
It's a 4 hour.
It's a 4 hour, Judge.
Okay.
They just said do any online one.
2 classes to do and the case gets dismissed.
Yes, sir.
Each class is around 2 to 4 hours. How long do you think it'll take you to get done?
It's not gonna take me long. I'll get on that today.
2 weeks?
Yes, Judge, that'd be
All right.
plenty of time.
Okay. All right. Good luck.
Thank you so much.
You
Thank you, Judge.
Overall, he's here in the back.
Come up, Mr. Lara. Are you representing him upstairs?
No, not upstairs, but I guess have learned that they have a TRAS set on the felony charge upstairs. He is made bond here on our case, and I think we need to get some bond conditions put in place. I talked with the state, we're amenable to no contact, no going near the protected address that is the subject of the individual.
I'm going to put a monitor on you though. You're a flight risk and you're on felony probation. You continue to do whatever you want to do when you want to do it. The court system doesn't work like that. And I'm going to tell you now, you ever take off on me again, I'm going to make your bond so high you'll have teeth falling out. Do you understand?
When a judge says, "I'll make your bond so high you'll have teeth falling out," that's not poetry. That's a warning shot. In plain English, he's saying stop running, stop wasting the court's time, or next time, you won't see daylight till your trial. It's tough love, courtroom style.
For sure.
You will now get a leg monitor so we know where you are at all times. It's a GPS monitor. If you fail to charge it, I'm going to revoke your bond. All you're doing is enriching bonding companies every time you take off, because all we do is we revoke it, raise it, you're throwing money. So if you have a lot of free money, great. Do you understand?
For sure.
You're not to have contact with the complaining witness. You're not to be in possession of any weapons. Do we know what is expected with the TRAS or no?
I don't at this moment.
No.
I think they just.
When is the TRAS set for? Do you know? Let me see.
February. And I think the felony date set February 19th.
So I'm not going to hold this case open for that long, right? So we need to figure out a resolution here. So what I'll do is I'll give you, 3 weeks. When you come back, you guys need to let me know what you want to do. But there's no way that I'm holding this case open for that felony case. No, you need to decide what you want to do here. And then when you come back next time, you must either accept the plea bargain or I'm going to set your case for trial. Do you understand? Okay.
Yes.
All right.
Okay.
Gotcha. See you in 3 weeks.
Judge, did you want the contact address?
I was going to try, it's not going to be able to be here. I usually give 1 reset per side and that's it. I don't know if you've had a reset before in this case. So if you have, that's it,
I'm seeing for under the settings.
What is the cause number if you don't mind?
Oh yeah, it's 2499532.
No, that can't. No, 2499153.
2499532.
Sorry.
Shane Proler. Shane Proler.
Judges, prep set.
I know, but has the state gotten have I granted them a continuance before? I know that this case has been reset for trial before. but I don't remember who did it.
I believe they had problems with the witness, maybe. And that something with one of the witnesses. I don't see a motion for continuance, but seems like there was a problem with one of their witnesses.
I always ask them to file a motion too, you know, but I don't know why. Who had this case before? Do you remember? What DA?
Your Honor, I believe it's Morgan's case.
That was Morgan's case.
I don't see a motion for continuance. Do you want one?
Judge, I apologize. There was no motion, but they were trying to get a transcript of a tape or something. If you look in the
Oh, that's right.
in the images,
They needed like 60 or 90 days to get it.
Right.
Right. I remember that. Yeah. Tell me, what's the word?
Yeah, Your Honor, we do have a note that we requested that translation. I don't have any notes in here regarding the discussions of PTI. We did have probation and time served on there.
Yeah, and she can't take time served. My position is, Judge, we don't know what's gonna happen over the next 4 years, but she is legally, but I don't know what.
Would you be interested in the PTI or no?
I would have to talk to her, Judge. I'd have to talk to her. Because of the circumstances are kind of strange with this, as you can well imagine, when they got a situation where it takes 60 to 90 days to get an interpretation. She was a trial. That's what the problem.
I mean, if she wasn't driving, then she can't do a PTI, because a PTI you have to admit responsibility, and if you're not driving, then you can't accept responsibility. You know, so. And I don't. Have you guys done any eval to see whether you guys can prove up driving? I don't know.
Reached out to Morgan to see if she had received any information that maybe she has the translations and she looked at it. I'm trying to see right now what she's done so far.
But we do have notes in our DA work product regarding what was seen on the body-worn camera.
And I'm not asking you to say anything,
Yeah.
right? I'm just, I mean, if you think it's good for trial, then it's good for trial, right?
Morgan has not received anything for translation. So we need to eval without.
You haven't?
We don't have it. So she requested and she never heard back from the translation request. So we would need to look at the case again without them.
I mean, I've literally reset this case for 90 days.
Yes, Judge,
if it never got done, I'm moving forward.
Yes,
I
Judge.
don't care.
Yes,
you know?
Judge, and we understand. So we would request maybe a week at the most.
No.
Okay.
Let's do this. Today's Tuesday. Let's reconvene maybe Thursday, at the latest Friday.
Yes, Judge.
But I'm going to tell you now, if the translation didn't get done,
yes, Judge,
don't care. We're going. I gave whoever it was 90 days for it to get done.
Yes, Judge.
If they never got done, then that's not, a lot of times you got to follow up, because so many people just don't do what they're supposed to do, and it sucks. But
And of course, you got people coming in and leaving, Judge, and I understand that.
And that's the other problem, is that there's the turnover, especially with.
Yeah.
And we understand, Judge.
So pick a day, Thursday or Friday. Let's come back, eval it, see if you have your stuff ready to go, and then we'll talk and reconvene. At least this way gives you at least a little bit of time to look and speak with whomever. And
yes, Judge.
Okay. All right.
Okay.
Thanks, guys.
And this young lady came and got me, so I appreciate that. Thank you.
It's like catching a unicorn. It really is. It's a great job. It's like winning the lottery when we get you, really. That's how popular you are.
Kind of died.
I know.
And
it's a shame. He was such a nice guy. He's great. When is it? When is her?
The 11th.
Okay.
So
I'll be there. Okay.
Right. Thank you.
Thanks, guys.
Travel.
Hey,
Yes, Anand has traveled.
No.
Yes, he does.
Is he here? He's coming.
It will take him a couple of days to get from India. But he has it finally. I'm floored.
It's wonderful. So however you want to do it, I'm happy to do it.
He needs the warrant lifted so he can travel because he's about to have a conviction.
Do you have a document saying what was it? He was gonna get. Was not yeah, but was it he was waiting to get a visa?
Yes, he had a work visa before COVID, and when COVID happened, it was like you got to go home, and so he went, and he's been there in India all this time, and he's been working his way to get back here. So finally, they were going to send him to upstate, but then he really wanted to be here, so they granted him this request, and it will take him 2 days, but he has his travel.
Do you have a plane ticket or something that says that he's going to come? Wonderful.
He says, oh, he starts giving it to me in email, and I said, no.
So this this gentleman, he picks up a DWI, and he ends up getting deported to India, right? Because we give him a PR bond. He's literally been working for, are we talking 5 years now?
Yes, he's
5 years to try to get a visa to come back here to be able to take care of this case.
Yes,
She's been staying with it that long.
Yeah. He
Amazing.
has resources to help me, so it's not.
You are.
He has resources. He's an engineer. He went to a company party. He didn't drink, and he decided to be cool. And cool called up.
Slick as grease, huh?
Yeah. So yes, this is his electronic e-ticket with the guitar.
No, look, I trust you. You're an officer of the court.
Yes.
I believe you. Just, we'll reinstate. Tell me what day you want, and we'll put it on for that day.
That'll be perfect.
It doesn't matter to me, whatever you want. So, we need to, the cause number at least.
Oh, yes.
Oh.
Okay.
It's DAS, right?
Correct. And.
Okay, let me see. Let's see who gets it first.
I got it.
Okay.
I got 2300140.
2300. That's it.
Yep.
Okay. Did you get that? It's 2300 140. I'm just gonna leave the bond as is and I'll reinstate.
So looks like he takes off.
No, it's 2300140. Das is the last name. DAS. Do you need it or no?
Oh, yes, because we're reinstating it a personal bond.
Yeah.
2300.
140. And then just tell Victoria whatever day you want, and then we'll put it on for that day. And then once we comes here, we'll just do or just whatever you need. Good job. Good job.
So we're putting him in for bond conditions?
Yeah. So whatever day, because he's going to need a couple days, but for whenever he lands. Okay.
Judge, do we need to bring this written out for the?
No.
No.